House Bill 53, which was heard on Wednesday.
This is another housekeeping bill suggested by the Municipal Association. It basically is meant to cover up, not cover up, but to eliminate a technical glitch in the law for that was imposed by House Bill 1408.
In the definition section.
Yeah, in the definition section. For the first time, let me give a little background. House Bill 1408, for the first time, differentiated between public bodies and public agencies and provided definitions for both of them. And the reason for this was because, as became apparent early on in both commissions' work, public bodies are those entities that can only decide things and can only act as a group, to which like this commission is a public body, because we can only act as a group. Individual members of the commission have no power to do anything substantive, and they can only act when there's a quorum and as a group. They have to vote on things, and therefore they're the only entities that can deliberate to accomplish their goals. Public agencies would be those entities like the highway department, locally the police department, the fire department. To use an example, a police commission would be a public body. A police department would be a public agency. In an agency, the head of the agency makes decisions and may have their own processes for making those decisions. But typically, there aren't meetings called, and they don't vote on things and then submit their requirements or their decisions that way. There may be some informal processes within agencies where people vote on certain things. When are we going to have the Christmas party? But typically, the head of the agency is responsible to a higher authority, and whether or not the matter has been voted on, is the agency head that's responsible for making the decisions. So the idea was that we would differentiate between public bodies and public agencies. The records requirements of the right to know law, retention and disclosure of records would apply to both bodies and agencies, but the meeting requirements would only have a application to public bodies. Now, it was discovered after the legislation was enacted that somehow or another the word agency or authority, the words agency or authority, were included within the definition of public body as it applied to local government entities. And so the legislation would remove the terms agency or authority from that particular provision of the definition of public body. The authority and agency are included in the definition of public agency, which is a separate provision. So that's the only reason for that. It's purely a housekeeping because, you know, when the fire department has a muster, you don't have to post a notice and make sure it's open to the public and so on.
Can I put the brakes on and ask some questions about that based on the hearing the other day? At the hearing the other day, folks who didn't think this was a good idea suggested, and I guess I personally might need some clarification. If you take this out, are you taking out, for example, an agency or authority of a legislative body, you know, local legislative body? Does that mean that, what was some of the examples? Oh, for example, they kept mentioning the local government center, saying the local government center because it really operates on public funds is sort of an agency or authority of local legislative bodies, and if you take this out, you are exempting them from the right to know.
I was at the hearing, and I testified at the hearing, and our office actually testified in support of the bill. And for the reasons that we agree with what John Lassie has just said, that it's merely a technical fix, and that as it applies, you'll see that it's applicable in the municipal section of the definition section of the right to know law. So it says that municipal agencies are not public bodies. And so I think what some of the testimony was confusing at the Judiciary Committee meeting was the meeting requirements of the right to know law and the records requirements of the right to know law. This isn't going to undo anything with respect to the records requirements of the right to know law. The LGC, based certainly upon the Superior Court decision of 2 days ago, seems to be in some respects subject to the right to know law, and that was pertaining to records. That opinion had nothing to do with the meeting requirements of the right to know law. So it's very important when understanding this law, this isn't going to have any impact like the Department of Justice. When I have a meeting with one of the investigators over there, that's not a public meeting. It's not going to be open to the public to sit down and watch me work, per se. But when I create documents, government records that are subject to review under the right to know law, that falls under the records requirement, and those records are subject to review under the law.
I think, Jim, it may be that the fact that this decision had just come out, which is not the first time that this has been considered. You recall that a year ago, the Supreme Court, in fact, I haven't read that decision the other day yet, Jim. I'm somewhat confused, as was Cordell when I talked to him, whether that was saying anything different than what was said by the Supreme Court a year ago, or whether there was just sort of like an implementation. But that was a completely separate a question that has nothing to do with the change in this legislation. It has to do with whether that entity, which was the healthcare trust, inherently falls into this category or that category for purposes of whether it is subject to the right to know.
Matter of fact, can I put another break here and we'll take a sub pit stop? Can someone explain the decision, what it was about, and what the decision was, so that we can all.
You read the one the other day?
Yes.
Have you read that?
I read it yesterday quickly yesterday afternoon. I had a fairly busy day yesterday, but generally what Mr. Attorney Smith is saying is that it did follow the health trust analysis, in that basically, generally, the local government center is so intertwined with government, providing health insurance and other functions for local governments throughout the state, that it falls under the test set forth by the previous firefighters, the health trust type case, that makes it subject to the right to know law.
So the it in this most recent case was not the subsidiary healthcare trust, but the municipal association itself?
That's correct.
Yeah, and I should note, as Cordell has said many times in these meetings, that the municipal association has for a long time taken the position that it would act as if it were covered by 91A until somebody says it wasn't. Obviously somebody was thinking about that, but to me that decision doesn't. It may have decided an individual issue, but it doesn't really change anything that de facto was in existence.
Right. I mean, and certainly this decision is subject to appeal. We'll find out within the next 20 some odd days whether or not the LGC is going to appeal. There are specific issues in the case that they may appeal. For instance, attorney's fees was awarded to the petitioner, so.
But was that Judge Conboy?
Judgment Gomez.
Oh, Judge Conboy.
Okay. You answered my question. All right, well, let's jump